Lee County Board of County Commissioners zoning hearing will commence. It's February 3rd. If we could rise for the invocation and pledge. I'm sorry, just a pledge. I pledge
allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good morning, Mr. Chair, Commissioners. We're going to ask Anthony Rodriguez to start with a brief staff presentation, at which point then we will turn it over to the County Attorney.
Great.
Commissioners, good morning. For the record, Anthony Rodriguez, Principal Planner with the Zoning Section of the Department of Community Development. The case before you this morning is FFD Land Company Incorporated versus Lee County. This is a request to move the draft development agreement to a second public hearing scheduled for March 3rd, 2021 at 9:30 a.m. The development agreement would provide for the issuance of development orders and development permits pursuant to Section 70.01 (4) Florida statutes to provide for the development of the FFD property. The property is located at 22030 through 22036 Big Lou Road. Consists of approximately 5,200 acres in the Southeast Lee County planning community. The hearing examiner reviewed the draft development agreement and concluded that the agreement is consistent with the spirit of the Lee Plan, protects the public interest served by the Lee Plan, and accomplishes the Lee Plan objectives through comprehensive conditioning, subject to one modification related to the schedule of permitted uses. Subsequent to the issuance of the hearing examiner recommendation, representatives from FFD and staff identified additional changes and clarifications to be included in the agreement. Those were outlined in a memorandum from the county attorney dated January 27, 2021, and staff respectfully requests that any motion to move the agreement forward to a second public hearing include those changes and clarifications. Now, turn it over to Michael Jacob from the county attorney's office with a legal perspective. Thank you.
Thank you.
Good morning, Commissioners. Today I will have a bit more conversation with you than we normally do. Just want to go through for the public and for the record the process we're in, where we were, where we're going, and then put some things onto the record as we go. I just want to briefly start out with the history of this case. As you're aware, we're in the process of a litigation over a Burt Harris case filed by FFD. The FFD application for a mine application was submitted and started in the process back in 2008, 9, and 10. As part of the county's moratorium on mining, this application was held up. Subsequent to the moratorium, the county adopted the Dover Coal Amendments and the comp plan amendments that you previously were aware of with regards to Goals 33. On March 3rd, 2010, the county amended its comp plans, and subsequent to that, the zoning application filed by FFD was denied on May 6, 2013. Subsequent to that 2013 denial, the county staff and the members of FFD have been in constant discussion with regards to the actual project, the claims being filed, and ultimately how to move forward. On July 3rd, 2017, the Burt Harris case that we have entered into the settlement agreement on was filed. And on October 6, 2020, the board held an executive session. Subsequently, the board adopted approved the settlement that set forward the process we're in today. Just briefly, the process we are following is set up by the statutory language in Chapter 70.01. And I want to go through briefly, if I'm going too fast, please let me know. We're going through some of the relief that's authorized under the statute to allow members of the public to understand why we're here and where we're going. As part of a settlement under the Burt Harris Act, the board is allowed to offer adjustments in land development, including issuance of increased density, intensity, or uses of areas of development. It allows for mitigation, including payments in lieu of on-site mitigation, conditioning of the amount of development or use permitted, location of development onto the least sensitive portions of the property, issuance of a development order, a variance, special exception, or other extraordinary relief. As part of that extraordinary relief, when the board provides a settlement agreement and the applicant agrees to that, the statute requires some additional process. That process requires a determination with regards to the relief that was provided, and it provides for, under statute, that the relief granted shall protect the public interest served, and it allows for a determination that the appropriate relief necessary to permit or prevent the governmental regulatory effort from inordinately burdening the property. There are two processes within the statute that we need to understand. The first step is if the county's regulations are not met with this proposed settlement, the county must make some findings. Russell will go through additional elements to that later on in this discussion. I will not go through exactly which ones those are. The second part is if the proposed settlement has a effect of not complying with state statute, we must then file a petition in the circuit court and get the court's approval. This case was presented to you today has an effect of not meeting certain county regulations. Russell will go through those. We presented those to the hearing examiner, and in the process is the settlement provides that if you meet the intent of the regulations that you're not meeting, in this case we'll go through 7 of those, then you can get the approval. With regards to the state statute, the court makes a determination whether the proposed settlement meets those guidelines. On December 3rd, the hearing examiner held a hearing. As Anthony already indicated, her recommendation came out on July 12, 2021, finding that the proposed agreement is consistent with the spirit of the LEED plan, and that specifically the directives to protect and restore water resources, wetlands, wildlife habitat, and that the agreement accomplishes the county's goals to protect and enhance the environmentally significant land contiguous to conservation areas. Notice of this hearing and other hearings were published in the news press, and mailed notice to adjacent residents within 750 feet of the boundaries of the project were sent. To date, during the public hearing or the hearing examiner, 2 members of the public were present. Only 1 spoke. We also received comments from the Conservancy and the Audubon subsequent to that hearing. I believe each of you have received a copy of those memos. Just briefly, I will not go through all of those, their issues with regards to the proposed development. They can speak for themselves, but I just wanted to highlight a couple points. The Conservancy appears to have made the most concerns with ensuring development occurs in the secondary panther habitat. They also provided a map that showed you green areas and pink areas and those things. County staff and the applicant through this process have developed proposed development pods that stay within the secondary panther habitat to the greatest extent possible. There are some areas of the proposed development that are in what were pink areas or the primary panther habitat areas on the map that was provided by the Conservancy. Those areas that are within the pink yet are still within the highly disturbed farmlands that are on site. We think we addressed most of their concerns with regards to the development, but again, they can address any concerns they have. We also received comments from the Audubon Society. Mr. Cornell's here. He can go through some of those in greater detail. However, the primary concerns appear to be with regards to the future maintenance activities on the site, and majority of those issues will either be addressed through enforcement mechanisms or ultimately through the conditions that are proposed. And as I said, Russell will go through most of those conditions with you. At this point, I do need to enter into the record the notice of public hearing, the memos that were provided to you with regards to the additional amendments to the development agreement, and ultimately, about 2 weeks ago, you received the electronic version of the submittal application with regards to this case. I'm going to enter that into the record now. That will serve as the basis for the board's decision, as along with the hearing examiner's recommendation. At the end of the hearing, we, as Anthony indicated, respectfully request that your motion be to set this for second and final public hearing on March 3rd, and that your motion include the proposed revisions that were submitted with regard in the memo that was sent to you last week. The hearing today is not a standard zoning hearing. Any members of the public that are here can participate. You do not have to be a participant of record. The board's 3-minute rule applies to this hearing, and the hearing is not subject to ex parte communication rules under Chapter 2 of the Land Development Code. All right, I think that covers what I need to put into the record and what I need to discuss today. If you have any questions on the process and where we're going from here, please let me know.
Any questions for the attorney? Thank you very much, sir.
All right. One other thing, staff will not be having a presentation. The presentation for both sides will be presented by Russell and his group.
Russell, you want to come on up?
Good morning, Mr. Chairman, members of the board. For your record, I'm Russell Schropp with the Henderson Franklin, a law firm here today on behalf of FFD Land Company, Inc., who is the petitioner, I guess, in this meeting. I'm here today with my partner, Richard Aiken, and we represent FFD. I will note for the record that prior to the hearing, I submitted a copy of our PowerPoint presentation, which will go through to the clerk and also to the court reporter, and I'd ask that it be incorporated into the record of this proceeding. Also here today on behalf of FFD is our project team that includes the folks listed on the slide here. Jamie Weisinger, the Vice President of FFD, is here today, along with Dan DeLisi, who will address you shortly. Dan and I will handle the bulk of the presentation today on behalf of FFD. The other members of the team are here and certainly available if you have any questions in any other substantive areas, but include our engineers, Elizabeth Fountain and Josh Evans, our geologist, Kirk Martin, who handles water quality issues, Ted Treesh, traffic planner, Andy Woodruff, the project ecologist, and myself and Richard Aiken. Michael had a very thorough presentation on the history and what brought us to this hearing today, so I'll be able to short circuit through a lot of this. But this lays out the basic procedural and historical background of how we got to this hearing today. The rezoning was denied in 2013, as Michael indicated. The Burt Harris claim was filed with the county in 2014, and in 2017 we filed a complaint in circuit court under Burt Harris and other remedies. For the next 3 years, there was basically pre-trial litigation occurring, and ultimately we were able to develop with the county attorney's office a stipulation settlement that was approved by this board last October. The stipulation of settlement basically did two things. The first is it required FFD to submit a proposed development agreement to the county for its consideration. And the second was that the stipulation established a process by which we would review that agreement and hopefully resolve the litigation. FFD did submit the development agreement in late October. It was reviewed by county staff, and we made some revisions to that agreement at that time as a result of their review. The revised agreement was then sent to the Lee County Chief Hearing Examiner in November. A hearing was held on December 3rd before the Chief Lee County Hearing Examiner, and her recommendation was issued on January 12th. The process that we established in the stipulation now requires 2 hearings before this board, the first today and the next hopefully scheduled in 4 weeks on March the 3rd, and also a final hearing before the court will be required if the development agreement is approved by the county and FFD. Mr. DeLisi will provide in greater detail, he'll go into greater detail on what is actually provided in the agreement, the conditions of development and other matters. This is a quick summary, a nutshell summary of what is provided under the agreement. The development parameters, development rights that FFD would receive under the agreement are basically summarized in the first 4 bullet points there. It would include a gross residential density of 5,208 dwelling units, or 1 dwelling unit per gross acre. These would be phased in over time under the agreement, and it would also include standard amenity uses that you'll find with typical residential development. And it also provides for 100,000 square feet of commercial and 50,000 square feet of office research and development for the site. The remaining bullet points basically address the public benefits that the county will achieve through the development agreement that's been proposed, and these include dedication of 56% of the property to conservation easement purposes. 65% of the property will result in open space. There will be a phased restoration of wetlands and flowways within the property in accordance with the development schedule. There will be traffic mitigation in the form of both impact fees and prop share payment for development paid at the time of DO. There will be Lee County Fire EMS impact fees paid, as well as a prop share for county EMS. And there will also be the other standard impact fees that will be paid as development progresses. And then FFD, as part of the agreement, agrees to relinquish its claims for mining of the property in perpetuity, and also releases its claims for damages under the Burt Harris claim that was filed. Mr. Jacob went through the purposes of the settlement provisions that are included in the statute, so I'll skim through these because they would be a little bit redundant to what Mr. Jacob already explained. But we have proposed a development agreement that contains certain variances and deviations from Lee Plan provisions, Land Development Code provisions, and state statutes. The purpose of going to the hearing examiner under our stipulation of settlement was to determine whether the development agreement protects the public interest served by the regulations that we are varying from. Those include, as I said, Lee Plan policies and Land Development Code provisions. It also includes 2 sections of the statutes that require compliance with the comprehensive plan. The purpose of the hearing before the hearing examiner was to address that issue and to have a special fact-finding hearing on that issue itself. The hearing before the hearing examiner that was held on December 3rd was for this single purpose, and after the hearing examiner issued her recommendation and made the required findings that the agreement serves the public interest protected by the contravened regulations and also accomplishes Lee Plan objectives by conditioning development to protect the public interest. And the hearing examiner also found that the public interest served by the contravened statutes would remain intact for 2 reasons. The first that she identified in her report was that the process has provided and will continue to provide an equivalent opportunity for public input through the process that is being followed pursuant to the stipulation. And the second reason was that the agreement actually implements the criteria found in the Lee Plan Overlay District that guides development in the DRGR land use classification and in Southeast Lee County. As Michael indicated, the hearing examiner recommended approval of the agreement subject to 1 modification to the schedule of uses and 2 minor wording changes to the development conditions. These changes are acceptable with FFD, and I'll talk about them later in our presentation. So that brings us to our hearing today, the first of 2 public hearings scheduled on this matter. Purposes of today's hearings are set forth on this slide. Basically, it's number 1, to consider the hearing examiner's determination that the agreement serves and protects the public interest served by the contravened regulations and statutes. Secondly, it's to determine whether the relief granted by the agreement is the appropriate relief to prevent the governmental regulatory efforts from inordinately burdening the property. Those are keywords under the statute that we are here today under. And lastly, the purpose of today's hearing is to determine whether to proceed forward with the agreement and move forward to the second public hearing, which would be on March 3rd, and then ultimately to the court settlement or the court hearing. At this point, I'd like to bring Dan DeLisi up to go through a somewhat shortened version of what was presented to the hearing examiner, but we are going to cover some significant ground with this presentation. I would like to have that as part of the record as we proceed through this process and ultimately go to the court proceeding. So unless you have any questions of me at this point, I'd like to bring Dan DeLisi up to go through some slides, and I will be back later on to summarize.
Any questions?
You made reference to or pointed at one of your bullet points on what the applicant here would be doing to comply with the spirit of the Lee County ordinances, referred to phased wetland restoration. Can you give me a sense of the timing of the phasing? I mean, is it a 1 year, a 5 year, a 20 year, and the nature, if you can compress the nature of the restoration that's going to be required?
The timing or phasing of it is tied to actual development of the property. So as development proceeds, the phasing of the restoration and environmental enhancement work will proceed. It will proceed in a manner such that at all times we will maintain at least a minimum of 56% of the site being restored relative to the amount that's being developed. So that we'll always have that minimum balance of 56% as we proceed through development and the phased restoration activities. As to the actual nature of the restoration, may I please defer that to Mr. DeLisi and perhaps our environmental consultant, because they would be better able to address that than I would. And Mr. DeLisi will come up, and I'm sure he's taking notes at this point and can.
He's going to present later?
Yeah, right after me.
Okay. Oh, Dan? Oh,
Yes.
Okay. He heard the question. I'll be curious whether we're restoring what was previously farmed, for instance, that's already been interrupted, and how much of the total 56% we're talking about.
Yeah. And I'm sure Mr. DeLisi will cover that in his presentation.
Thank you.
Thank you very much.
Thank you. Any other questions?
Okay. Thank you. Appreciate it.
Thank you.
Okay, so for the record, Dan DeLisi, as Russell mentioned, I was retained by FFD to assist them through the settlement process as a land use planner. So I'm going to run through this presentation, and I will try and answer your questions to the best of my ability to describe for you what's going on. But just from a macro standpoint, obviously you have a very large site. It's much larger than any of the environmental enhancement and preservation communities you've approved to date, more than double the size of the next closest. And so you have the opportunity for some very significant restoration. And if you look at the aerial, and then when I show you the restoration areas, you'll see how many farm fields will a future developer will be on the hook for restoring back to its natural lands. And some of that is dependent on what's, where it is. Obviously, you can see the farm field adjacent to Flint Penn Strand, and you would assume that the restoration would be of similar nature to what's going on around this farm field in Flint Penn Strand. What's going on in the south may look a little different. But overall, it's going to be a mix of upland and wetland habitats, similar to the other restoration activities that have occurred in the area and the environmental enhancement and preservation overlay. I wanted to show you all a regional aerial because it's helpful to understand what's going on in the area. And the overall public interest that's involved here. You can see the site in the context of the Crew ecosystem. You have Flint Penn Strand to the west, and then you have Crew managed and owned by the South Florida Water Management District, and Audubon Corkscrew Swamp Sanctuary to the south and to the east. So there's a lot of environmental lands here, and this farm is almost the thumb that sticks into them. You also have development contiguous to the property on the north side. That's the place on the northeast corner. Then you see Verdana Village over to the east of the property. You have urban infrastructure going across the frontage of this property. And so the developments, Verdana Village and the place, provided the framework for the development conditions that are included in the settlement. And of course, the environmental areas surrounding the property provided the framework for how to look at restoration of the restoration areas. The settlement agreement is structured to include something akin to a plan development. So you have the master concept plan, the schedule of uses, and the conditions of development, all of which I'll show you. And the master concept plan is structured similar to plan development master concept plans of this scale. So again, this is 5,200 units, 5,200 acres. It's definitely a longer term project than other projects along the corridor. There's more that's going to happen, but over a longer period of time. But you can see the general structure of it, where the restoration areas are. There's a spine road coming down into the property with development pods off of that spine road. As Russell pointed out, we have 56% restoration, conservation, and those are all the hatched areas that you see. And just so you know, the dotted hatched areas are wetlands, and the hatched area with the crosshatch are upland areas. So all of those upland areas are farm fields that will be restored into natural habitat. We have restoration that includes.
Apologies.
That's fine. It's better you than me. Over a half a mile contiguous to Flint Penn Strand, and over a mile of depth, approximately a mile and a quarter of depth on the south of contiguous preservation. So the striking thing about this proposal is how much very large conservation and restoration area contiguous that we're able to provide on this site. I do want to note two things about this. The 65% open space consists of the preserves, which you see, but also open space areas within the pods themselves. So within the pods, you still have lakes, buffers, and all of the other elements that are considered open space in the LEAP plan and the Land Development Code. The R&D facility that was mentioned before, the 50,000 square feet of R&D, that's an existing facility already on site, and that's shown on the master concept plan up in this location. And the intent here is that's part of a development pod that will eventually be, it may be phased out over time. But that's an existing use. There also is existing farm worker housing on the site that would also be anticipated to be phased out over time. The parcels were numbered, a little blurry on this, but consistent with how we anticipate development happening, and that would be starting at the north and then going around the west side and then up on the east side. And the reason for that is to have an orderly phase out of agriculture, where the development will always access Corkscrew Road at the north, and the agriculture will continue to have its current access, which is along 6L's Farms Road. And so you keep the agricultural use separate from the residential and commercial uses, the traffic stays separate, and you have an orderly phase out. The schedule of uses that was provided has commercial uses, residential, and then amenity parcel uses. The commercial uses are identical to Verdana Village. We just took the uses from that, put them in here. The residential uses are adapted from other environmental enhancement and preservation communities. The only difference really is there's more of a variety. Again, there's a longer time frame for development. We anticipate that there will be more of a mixture of housing types within the different neighborhoods that are set up. So some single family, some multifamily, some attached, detached products. So we have more product options. And then we do have 2 designated amenity parcels on the plan as well, but we also allow for amenity uses within the parcels themselves. There is a restoration phasing plan that is included in the settlement, and again, this just allows for the orderly phase out of agriculture and the phase in of restored area. As Russell noted, the way the condition is structured is at all points in time, there has to be a minimum of 56% restoration for overall development area. But there also has to be no more than 1 unit an acre approved on that area. So we've limited it so any future development can't get ahead on the density and can't get behind on the restoration area. Similar to the other environmental enhancement and preservation overlay communities, we have essentially the same development conditions. And I say essentially the same because some of the conditions were providing some of the data and analysis at the time of development order rather than at the time of plan development. But fundamentally, the conditions are exactly the same. It's the same data being provided, just at a different point in time in the process. Condition 4 requires the human-wildlife coexistence plan. We've actually already submitted that to staff, and that was part of the application. Condition 7 requires the restoration and conservation areas, 56% consistent with the Lee plan. The Lee plan requires 55%. We're providing 56%. But again, that's the condition is similar to other conditions. Condition 10 is the Florida-friendly low irrigation landscaping, and 11, the prop share, as Russell pointed out. Same thing with conditions 13, 14, 15, and 18. They all have to do with meeting the intent of the density reduction groundwater resource area by limiting water consumption to the greatest extent possible, and I'll go through exactly what's going on there, and also making net positive improvements to water quality through the restoration activities and the removal of agriculture. We do have 2 deviations that are requested, and again, these deviations are similar, if not the same, as other environmental enhancement and preservation communities. The first would allow for suburban road design standards to be applied on this property. And as you've noticed, if you've been out to the place, that is a community designed as a suburban subdivision. The land development code has different road design standards based on whether you're in a rural area in the Lee plan or an urban or a suburban area. And so technically the place, Verdana Village, this property are all in a rural land use category, and therefore in the land development code you would ordinarily have to provide rural design standards, swales and the like. And so we're asking to provide a development form that is consistent with the suburban design standards. The second is just to allow temporarily a single access point. So you see these northern parcels, parcels 1 through 5 are all up in here. As these get developed, you can envision a situation where this parcel at the north develops and you only build this access point. You don't put in all the infrastructure like the access point to the east. The land development code would require 2 access points. So as a temporary measure, just having 1 access point with the understanding that over time and by the development of the 5th parcel, you would definitely have that 2nd access point. So when we looked at the settlement agreement with staff and we created the joint memorandum that you all have, we noted that based on the overall settlement agreement, this agreement is consistent with the Lee plan in several areas, as we noted in the report and you can see on the presentation. Overall consistent with the purpose and intent of the DRGR, the wetlands land use category, and the environmental enhancement and preservation overlay. However, as Michael and Russell pointed out, there are some specific areas where we are inconsistent, and for those areas we need to talk about how the public interest is still being protected despite that inconsistency. And just from an overall standpoint, again, this proposal provides a little over 2,900 acres of restored environmental area. I think it's 2,916 acres of restored environmental area. That's a tremendous amount of restoration, and it's restoration at no expense at all to the taxpayers. So just from a public interest standpoint, I think we all see the public interest there. So let me go through the specific policies now. Policy 33241 requires that in order to make use of the provisions in the environmental enhancement and preservation overlay, you need to be designated on map 17. And the extent of the overlay extends no more than 1 mile south of Corkscrew Road. First, with map 17 wasn't created to proactively designate properties in the overlay that would be targeted properties. It's a process that you go through. You submit a comp plan amendment, you do the designation. There's really no substantive issue there. 1 mile south of Corkscrew Road is a limitation on this property that would, if applied, diminish our ability to do all of that significant restoration in the most targeted areas. So by allowing the extension of the overlay south of Corkscrew Road, we're able to take in the whole property, not just that northern section, and provide, again, 2,900 acres of environmental restoration at no expense to the taxpayers. Policy 33242 requires that this be done through a plan development process. We're doing this through a settlement agreement. So the end result is the same. You're still getting a master concept plan. You're still getting the same conditions of development, and you're still getting the same schedule of uses, schedule of deviations, everything that would go in a plan development. You're just doing this through a settlement agreement. Again, the design requirements we have aimed, and we are consistent with the design requirements of the environmental enhancement and preservation overlay, just through a different process. Policy 332.4.2D requires dedication of the conservation areas to a homeowners association or a Community Development District. And I do want to reemphasize that this property, I believe, is unique in two ways. One is that it's large. It's much larger than the other environmental enhancement preservation overlay communities. But it also has very significant, regionally significant environmental lands to the west, east, and south, managed by other entities. And so what we tried to do in the agreement was allow for a future option of maintenance by the South Florida Water Management District. It's just an option. We didn't want to be down the line 20 years from now and recognize that it would be more effective management to have one agency manage all of the environmental areas and then realize that that's inconsistent with the Lee plan. So we're throwing that in now as a potential option. It would still be managed by a single entity, though.
Before we leave that point, Mr. Chairman, may I ask just real quickly, spoke with Attorney Schropp before the meeting, and I appreciated what was written in the memo from January 19th from Mr. Schropp, saying that in order to avoid burdening taxpayers outside of the FFD project with the cost of maintenance, a maintenance trust fund, a special assessment, or some other mechanism could be established as a means to defray such costs. You know, the South Florida Water Management District is still a taxpayer-funded organization. My request, and I intend to support the agreement today. My request is that between now and the next public hearing, could we look for some way to codify that segment in the memo where we talk about a mechanism that would ensure that even if it does transfer to the Water Management District for maintenance, which seems to make a lot of sense, that the taxpayers to that Water Management District wouldn't bear the burden of the cost.
Well, I mean, that's definitely something we can look at. The one note I would put to that is the district can't be compelled to take the property. So if they don't feel like they can manage it, or if they don't feel like it's in the best interest to manage it, I can't see why they would accept it. We don't have the ability to compel them to do it. But yes, I agree with that, and that was always our intent. And typically when you would dedicate land to a public agency, specifically the Water Management District in this case, I'm familiar with. There would be a maintenance amount that would go along with that dedication to defray the long-term costs.
Great. Yeah, no, it sounds like you understand where I'm going then.
Yeah.
Because the board of the Water Management District may not be as familiar with, the reasoning for this policy and the fact that we were really, truly trying to get that 2,900 acres at no expense and also no future maintenance expense as well. So,
Yep.
Okay.
Yeah. So moving on, policy 33.2.4.2E requires 55% of the property to be placed in conservation easement within 5 years of the first development order. What this settlement agreement includes is a phase out of agriculture and a phase in of restoration area, and obviously that'll happen at a period of time greater than 5 years. And so that allowance is important. I think the public interest that's protected by this is that we're dealing with such a large property. And I mean, that type of requirement makes sense if you're restoring 1,200, or if you're dealing with a property 1,200 acres, not really a property that's 5,200 acres. I will note each phase is a sizable property in and of itself, and we have looked at the phasing plan and the types of benefits that you can anticipate with each phase. And so I want to run through that just quickly. For both water supply and water quality. So with each phase, we're seeing between a 25% and a 64% reduction in water consumption. with an overall 49% drop in water consumption. And this isn't surprising when you understand agriculture and consumptive use. So it is a significant amount of water quantity that is saved by this proposal. The water quality benefits are also pretty significant. Each phase we're seeing between 76% and 89% reduction in total phosphorus for an overall reduction of 87%, and between 29% and 54% reduction in total nitrogen for an overall total reduction of 45%. So again, significant water quality and quantity benefits by each phase. Policy 33242I requires elimination of agriculture at the first development order. Again, for the reasons I noted before, this agreement allows for a phase out. For the elimination of agriculture on such a large property like this at an early stage, I think we've noted in both the joint agreement and elsewhere that you want the overall property to be actively managed, the water management system managed to prevent erosion and decay, and to make sure that you don't have an infestation of exotics, especially in this area where you're surrounded on three sides by other natural preserves. So continued management of the property is very important, and I think that's what ultimately is what protects the public interest. Policy 33243B limits density for Tier 2 properties to 1 dwelling unit per 2 acres. This property is designated as Tier 2, not Tier 1. It's the only Tier 2 property that's on that priority restoration map in the Lee plan. When you look at, and so the environmental enhancement preservation overlay allows for 1 unit an acre for Tier 1 properties, 1 unit per 2 acres for Tier 2. But when you look at the Lee plan and how it distinguishes between Tier 1 and Tier 2 properties, that's defined in two policies, 3312 and 3313. And what it states is that Tier 1 and Tier 2 have the exact same ecological value. The only difference is that Tier 2, for whatever reason, a finding was made that Tier 2 is more viable for long-term agriculture. So it was put in for, Tier 2 rather than Tier 1. But the environmental enhancement preservation overlay was set up to incentivize the most beneficial or targeted environmental lands to promote restoration on those properties. And if you're getting the same environmental lift and benefit as a Tier 1 property, it only makes sense that you provide the same incentive to get that done. So again, Tier 1 and Tier 2 are the same ecological value, the same environmental value. And, obviously when you look at that regional aerial, that's no surprise. You look at the surrounding properties, you look at where this is situated, and for the ability to provide those habitat wildlife connections between Flint Penn Strand and the rest of Crew to the east, there's a lot of environmental benefit. And so the public interest protected is again granting the same density incentive for the restoration of the same types of natural lands as Tier 1 properties, and being able to successfully incentivize the restoration, as Commissioner Hammond said, at no cost to the taxpayers. And then inconsistencies, and I'm almost finished with the inconsistencies. Policy 33244D and 3325 limits commercial development to 300,000 square feet. Between Verdana Village, Old Corkscrew Golf Club, and the Small Brothers Comp Plan Amendment that you all transmitted about 6 months ago, you have about 267,000 square feet already approved or pending. When the analysis was done for those comp plan amendments, I think Verdana Village showed a much greater need than 300,000 square feet. Small Brothers and Old Corkscrew Golf Club showed a need for 300,000 square feet in that market area. And the joint memo goes through all of the data and analysis that went into that. I'd be happy to walk you through that if you're interested. But obviously, when you add 5,200 new units to the market area, that's going to increase the market need. And understand this isn't just a convenience store or a Publix. We're talking vets, dental offices, real estate offices, all those things that are typical small neighborhood commercial uses that you want close to the residents that utilize them, so that they don't have to keep driving farther west to along Corkscrew Road to I-75 to the shops at Grandeza, or even farther into Estero to get those neighborhood commercial needs. And so the cap is at 100,000 square feet, which is consistent with the Lee plan on just providing neighborhood commercial or community commercial rather than regional. So we're not talking about things that would attract people from outside of the area, just things that would keep people inside the area. And then just as a summary, again, this proposal is structured similar to prior approvals in the environmental enhancement preservation overlay. The public interest is being protected by requiring the same level of analysis prior to development and the same level of design that you would see for the other communities in the overlay. The county is gaining almost 3,000 acres, 2,916 acres of restored natural lands, and a significant reduction in both water use and nutrients in the watershed. And with that, I'll turn it back over to Russell Schropp.
Unless you have questions of Mr.
Unless you have questions.
Any questions with Dan?
Good job, Dan.
Thank you.
Thank you. Two last slides to go over, and then we'll conclude our presentation. After the hearing examiner recommendation was issued last month, I transmitted to Mr. Jacob some revisions to the agreement for the county's consideration. These were forwarded to Mr. Jacob, and I believe, based on his later memo and also Mr. Rodriguez's comments this morning, I believe the county recommends that these changes be included in the original agreement that was submitted, should you choose to send this agreement to the second public hearing and ultimately on to court. Generally, these changes, I think, are relatively minor, but just so I get them on the record, there were the three recommendations from the hearing examiner herself. The first was to eliminate a waste transfer station from the schedule of uses. That was certainly not intended and should be deleted. The second was to delete the reference in condition 6 to pasture areas because there are no pasture areas on the property. The property ag uses are row crops and citrus at this point, so that was just an error. And also to amend condition 20 to require separate letters of availability for certain services at the time of DO rather than at the beginning of the project when may not be able to be issued. So it will continue to get letters of availability as we go through with individual development orders. The other changes were proposed by FFD to the county, and I believe the county concurs, or the county attorney's office and county staff concur. Again, they're relatively minor. One would add a condition 1C III to expressly recognize that individual parcels within each phase may receive a DO. We don't intend to get one DO for each phase. There will probably be multiple DOs for each phase. The second is similarly, we'd like the ability of make it be clear that we can pursue multiple development orders simultaneously. There may, in fact, be more than one development order under review at any one time. And I think that's contemplated by the agreement, but just to be clear. We talked about the amendment to condition 6 to allow for conservation easements to be dedicated to governmental entities And so we've incorporated that into the agreement. And Commissioner Hammond, yes, during the interim between the first and second hearing, I'd be happy to work with Mr. Jacob on appropriate language to address the maintenance funding aspect of, if in fact it does go to a governmental entity. And the last change would be they were just minor amendments to the property development regulations with regard to setbacks, height, and lot width. And basically, they will allow us to provide greater flexibility to meet the open space requirements that we've committed to. So those are the changes that we would like to be incorporated.
Could I inquire?
Certainly.
I'm easily confused, Mr. Schropp. Earlier, y'all in your presentation mentioned that in lieu of development orders, the settlement agreement that we're talking about here was going to do that job, or words to that effect. So we're now talking about development orders again, and help me understand.
Okay, certainly. Yeah, and I didn't pick up on that comment. I don't know if it came from me or Mr. DeLisi or Mr. Jacob, but I think this agreement is in lieu of going through the zoning process that would typically be done, and the comp plan amendment process that would be done and has been done for other projects in this part of the county. We certainly anticipate the need to obtain development orders as we move forward with development through the local development order process that the county has established, and that will be
I thought that was in one of the overheads that we looked at. A specific reference to the settlement agreement would deal with the development orders in lieu of the normally required development orders.
That is correct, and I think the confusion is over the way the statute defines development orders and what we're referring to as our local development order requirement. A development order under statute includes zoning approvals and other permits that would allow for building and issuance of development. So that's where the confusion's at. The settlement agreement provides a process for approval of, in essence, a plan development and the comp plan amendments that would have been necessary to address the contravened regulations. The applicant, the development, the future developers are all required to still meet the development order requirements and all the other Chapter 10 and Chapter 34 requirements unless it's been addressed differently here.
And your head's going up and down.
Yes, sir.
With what he just said.
Yes, sir.
Okay, thank you. That helps.
More articulate than me, but I agree with him.
Thank you.
I will close with a reminder of the two required findings that must be made in order to approve an agreement that contravenes regulations and statutes. I mentioned them earlier in my presentation, but they basically include, number one, that the relief granted through the agreement adequately protects the public interest served by the contravened regulations, including the plan policies, land development code provisions, and statutes that we identified, and Mr. DeLisi went through in some detail during his presentation. I would respectfully suggest that the determinations that have been made by your hearing examiner and the presentation made by Mr. DeLisi have adequately provided sufficient documentation to make this finding. The second finding is that the relief granted through the agreement is the appropriate relief necessary to relieve the property of the inordinate burden caused by the county's regulation of the property. And in this regard, I would note three things as support for this finding that we've gone through in preparation of all the materials and the presentation today. The first that I would note is that that makes this the appropriate relief is that what FFD was deprived of essentially was the right to engage in a particular use of its property, mining, back when we applied in 2008, 2009. What the agreement accomplishes and makes this the appropriate relief is the right to engage in alternative uses to mining on the subject property that will restore the ability to use the property in an economically productive manner for the property owner. As such, I think it is the appropriate form of relief to be granted as part of this agreement. The second reason for finding that it's the appropriate relief is that the project basically follows the goals and parameters of the environmental enhancement community overlay that you have adopted for Southeast Lee County in the DRGR area, with a few exceptions that Mr. DeLisi went through and the hearing examiner reviewed and found that the public interest served by those exceptions were still being maintained. This overlay was established to achieve significantly greater restoration and enhancements that had been determined to be important in the DRGR area in Southeast Lee County through the granting of development rights for the property. In this regard, providing FFD with certain development rights that are contemplated by the overlay in exchange for certain environmental enhancements and restoration would seem to be the appropriate relief contemplated by the overlay in your comprehensive plan. The last I would mention, the third reason why this relief is appropriate is because it follows and is consistent with the basic uses, conditions, and development regulations that the county has adopted for other communities in the southeast part of Lee County in the DRGR. These prior approvals on which this agreement was actually based reflect the appropriate relief that should be provided under the settlement because it is what has been provided and approved already for similarly situated properties in this area. With that, we conclude our presentation and would request that you address the required findings and move the agreement onto the March 3rd hearing with the proposed changes that we outlined. And again, Commissioner Hammond, I will work with Mr. Jacob on the issue that you raised. We are also available for any questions you might have at this point.
Any additional questions?
One last, and maybe Dan, I should have asked you while you were here. You made reference to 2,900 acres, or a couple more than that, of restored natural lands. Would you give me a layman's version of what a restored natural land is going to look like? I mean, is it cypress heads, or is it oak and cabbage palms and pines, or what is a restored natural land where it was previously farmed, was my understanding, this 2,900?
So it's a mix. Some of the areas adjacent to Flint Penn Strand are heavily infested with exotics, and so...
That's not what you're going to do.
Well, that's some of what we're going to do. Some of it is farm fields that we're taking from being a farm field and we're putting into plantings either with upland or wetland habitats, depending on what the surrounding landscape is and what the ultimate flowway restoration or restoration plan entails. I mean, I can't give you a very specific planting plan at this point in time. That's the thing that we have pushed to development order. But we have put in our narrative that it will be a mix of upland and wetland habitat, and it will include foraging areas for wading birds. So
in the wetlands area, but I'm just, the trees that I mentioned, cypress, pine, cabbage palms, oaks, those are what I've observed as natural habitat, natural woodlands. But you're not telling me there would be something other than that.
Yeah, I mean, I'm not suggesting.
You don't want to be specific, but and I just want to know what restored and natural lands are going to look like. And it takes 25 years to establish that habitat.
So I guess and I'm sorry for interrupting. I guess the easiest way of envisioning, in my opinion, of what it will look like is just looking next door at what that looks like, and that would be.
Well, that would be what I've described, and a whole lot of the crew land is like that. So That's a good answer. I'll rely on that we look around us and see what, there's the definition of natural. Thank you.
Any other questions? Anyone from the public like to speak? Yes, sir.
Thank you, Brad. Good morning.
Good morning, Commissioners. Mr. Chair, thank you for the opportunity to address you on this settlement agreement. I'm Brad Cornell. I'm here on behalf of Audubon, Florida, that owns the Corkscrew Swamp Sanctuary, a 13,000-acre private sanctuary environmental preserve, and also on behalf of Audubon Western Everglades. So again, thank you to you all for letting us comment on this. First, I just want to say that this is a good development in terms of moving away from a 4,000-acre rock mine. I know we need rock, but we don't need it from this particular location. That would be a conflict with a lot of the crew lands that are adjacent to it, including Corkscrew Swamp Sanctuary, so this is good in our opinion. I have three issues I want to raise to your attention. I shared with you a letter that I sent by email, and you now have the hard copy. And so there are some other issues besides what I'm going to raise, but the three primary issues involve these. The first is that we, as land managers of conservation land, have to burn. In fact, we're required to burn our land by permit. The Army Corps of Engineers and the Department of Environmental Protection in the South Florida Water Management District have given us permits to manage our lands that requires that burning. We need to get burn permits from the Florida Forest Service to do those burns. The closer development is to where we're burning, the more difficult it is for us to get those permits. This is a problem shared with your Conservation 2020 land managers, with the Water Management District, with Crew Trust. Every land manager has this challenge in Florida. And so I will tell you that the 50-foot buffer between the development on the eastern side of this FFD is way too short. It needs to be something on the order of 3,000 feet. Otherwise, we can't do it. Our land managers have looked at this, and that is a very important point. Second, the restoration plan, as Commissioner you were inquiring, is still very vague. And so what we see on the map does not look like the best way to achieve regional flowway interconnections and restoration and regional large mammal and wildlife linkages. We think there are better ways to do that. We're very interested in sitting down with Lee County and with the developer to figure out ways to better accomplish those regional linkages and the restoration plan. And finally, I just want to comment about the issue you already have been speaking about, and that is long-term management of the preserves. It's our experience and over many years that that homeowners, I'm sorry? Yes, I will. Homeowners associations and CDDs are not good conservation land managers. And so we agree with the idea that you should be looking at somebody like the Water Management District or crew managers who should be taking that long-term management task and role. So thank you very much. We look forward to working with Lee County and FFD.
Thank you. Any other public comments? No other public comments? I'll close public comment.
Mr. Chairman, I'd like to move this item forward to the second public hearing on March 3rd, 2021, inclusive of the January 19th memo from Russell Schropp.
I have a motion on the floor.
Does that include the proposed changes?
That's correct, yes.
I have a second from Commissioner Sandilli. Any other discussion? All in favor? Aye. Anyone opposed? Motion carries. Thank you. I believe there'll be adjournment. Nothing else on the agenda. Thanks. Thanks.